Welcome, friends. Today we are going to see Article 14 of the Indian Constitution. It is a part of the fundamental rights that comes under Part 3 of the Indian Constitution. Article 14, 19, and 21 together constitute the golden triangle of the Indian Constitution. The socio-economic differences prevailing in India prone to discriminate the people, not only regarding the socio-economic differences but also based on caste, sex, religion, place of birth, etc. The preamble of Indian Constitution envisioned equality. As per the wish of the preamble, Article 14 was written by our constitution makers. According to this article, the state is not supposed to discriminate, and even if someone discriminates, the state is supposed to take action. That is, it has positive duty on it. Equality before law and equal protection of law. These are the two basic concepts we are going to deal with in this article. Actually, these two things, these two rights are given to any person residing within the territory of India. That is, it is not only given to all the citizens, but also it includes under its ambit the non citizens, that is, the aliens. Equality before law is a negative concept. It makes the state to abstain from violating equality and equal rights. No special privilege is given to any person regardless of their rank. That is, the same law applies to everyone. No one is above the law of the land. That is, in our case, the Constitution. No one is above the Constitution. It is the lex loci, that is, the law of the land. The concept of equal protection of law is taken based on 14th Amendment of US Constitution. Under this concept, the people should be allowed to enjoy their rights without any privileges or favoritism, and it is a positive concept. That is, as said before, state is supposed to take action to ensure the right to the citizens and other people. In Srinivas Theatre versus Government of Tamil Nadu, the Supreme Court held that the terms equality before law and equal protection of law, though they appear the same, they have the different meaning. Now we can see these two concepts separately. First comes the equality before law. It follows the principle that the like should be treated alike. That is, equals should be treated equally. For similar circumstances, similar laws should apply. That is, the same laws should apply. Right to sue and to be sued. So, these rights should be equal to everyone who are facing equal circumstances, who are in equal positions. No discrimination must be there when there is the case of similar circumstances. State of West Bengal versus Anwar Ali Sarkar. In this case, it was held that equal protection of law is the natural consequence of equality before law. That is, if there is equality before law, only then there will be equal protection of law. They both are interrelated. You can't say you upheld equality before law, but you only violated equal protection of law. Both goes hand in hand. Under this ambit, we'll see the concept of rule of law. It was propagated by Daisy. Equality before law is part of rule of law. No person is above law. According to the Dicey's concept of rule of law, it contains three meanings. Only two is relevant to us, so we'll take just two. First is supremacy of law, and second is equality before law. Supremacy of law means the government is not supposed to take any arbitrary decisions or arbitrary laws. Always the law must prevail. The supreme law, the law of the land, that is, the constitution prevails. And second concept, as we know, it is equality before law. Dicey actually gave an exception to equality before law to the monarch because in England it was considered that king can do no wrong. As every laws, even equality before law has its own exceptions. Shall we see what are they? First is Article 105 and Article 194. They give parliamentary privileges to both MPs and MLAs. That is, both MPs and MLAs are not liable for anything they say within the House. Then there is Article 359. That is, when there is a proclamation of emergency, the fundamental rights are suspended, and it includes Article 14. So, after the emergency ends, too, you can't go and challenge that my right to equality was violated as per Article 14. And another exception is Article 361. It gives immunity to the president and governors. Both are not liable when they do an act while exercising their powers and duties while they are in their office, while they are holding office. Next, we can jump on to the concept of equal protection of laws. In equality before law, we saw that like should be treated alike. But in equal protection of laws, we are seeing the same concept, but somehow it's different. That is, unlike shouldn't be treated alike. That is, unequal people shouldn't be treated the same. People might be in different positions and circumstances, and they shouldn't be governed by the same rule. As we saw, not all are equal, so it is impractical to apply the rule of equality, the right to equality equally. It doesn't have universal application. So the laws made should not be general. The Article 14 actually gives some space for reasonable classification. Only then the society can progress, though it gives some space for classification, that is reasonable classification. There should not be any class legislation, that is for particular group based on arbitrariness. Some legislations should not be made. If they are made based on judicial review, our courts will struck down those laws as unconstitutional. How would we know if there is reasonable classification or not? So there is a test to check whether the law is based on reasonable classification. That is, the classification should not be arbitrary, evasive, or artificial. Substantial distinction must be shown, proof must be shown, that is, the decision is taken, the classification is made based on intelligible differentia. That is, a common prudent man must be able to differentiate and understand that this is reasonable. For example, classification based on income is legible, and also classification for children. Child based laws are many in our country, right? So, that classification is also a reasonable one. This classification must satisfy the objective for what it was made. That is, if you separate those people based on income, that might be for benefits to low income people, like tax exemption. It is valid. Now, there are some case laws. First one, Re Special Courts Bill. In this, Supreme Court held that classification is needed, but you should not overemphasize or overdo the classification. The classification is just a subsidiary rule used by the court to facilitate equality, not the opposite. Then Air India versus Nargesh Meerza. In this, regulation were made by Indian Airlines. The regulation was air hostess will be retired from services at the age of 35, or if they are married within 4 years of service, or first pregnancy, whichever is earlier. The court held that Terminating based on the ground of pregnancy is unreasonable. It is discriminatory in nature because they actually have a ground that you can marry after 4 years of service. So, comparing these two regulations, they held the termination based on pregnancy is unreasonable and hence it is not valid either. Then we have DS Nakara versus Union of India. In this, Central Services Rules, Rule number 34 was challenged. And it was held that it violates Article 14 and it is unconstitutional. The rule actually made a classification between pensioners who retired before and after a specific date. That's why it was held discriminatory and hence invalid. I have given all the case laws I have mentioned here in the description. Please check it out.